Hello and welcome all to Lawyer. I am Krish Mahajan and I am your host for today. I extend a warm welcome to all. Data Privacy Week is a great time to remind ourselves of the importance of having systems in place to protect us and our activities online. Today, we are hosting a session on data privacy in Canada to look at the future directions of Canada's data security, that is, threat of all. Let us examine the elements of privacy in detail. And to share more on the topic today, we have Advocate Shashwat Jindal. Mr. Jindal is the director of Jindal Solicitors and Associates. He specializes in corporate law, intellectual property right matters, data privacy and protection, and maritime law. He is multifaceted and hardworking. We also have with us Arushi Makkar, who has been researching and working on various Canadian research projects and curating content and articles around various Canadian startups with Jindal, Solicitors, and Associates as their legal intern. Hello, sir, and hello, Arushi. Welcome to Mentor our session on data privacy in Canada. Sir, I'd like to start with you. What are your views on it?
Thank you for such a warm and amazing welcome to us. We have a lot of views, so in order to make it easier for our audience to understand, we have put everything into a presentation which I'll be sharing now. So, so what is basically data privacy? Data privacy, or like as we have quoted, that good privacy makes good business sense. And to maintain data privacy is of utmost concern for any business. Any discrepancy found can be catastrophic. It is crucial to maintain the privacy of the business organization, its employers, employees, and most importantly, its customers. And Canada has a very variety of privacy laws, and it is essential to know which law applies to your business. It is important to follow the laws right from the incubation period of the business or the startup. And Canada is way ahead of many countries when it comes to protecting data and personal information while abiding by the data privacy laws. And data is all sorts of data, and it can include information you take from your clients, or information which you have of your employees. And it can include a lot of all the data you have of certain individuals, because the personal data of an individual is their property. And if you're being interested with someone's property, you have a duty towards them to protect it and ensure that it does not get leaked or it doesn't get misused. So uh, that is why we have these laws in place. And so now we'll move on to the next slide. Canada has two federal privacy laws in order to protect the personal information. The first one is the Privacy Act. The Privacy Act is more towards the federal government organizations. Maybe, for example, you may take the IRCC, who takes care of all the immigration related matters. So they have a lot of personal information of a number of people, and they have a duty of care towards them to maintain the privacy of that information. So they are governed under the Privacy Act. Then we go to the PIPEDA, which is going to be the primary focus of this seminar. And the PIPEDA, as you can read, was the Personal Information Protection and Electronic Documents Act, which came in 2002. And it more of controls, and it provides that how private sector organizations should handle personal information. And we will be focusing on PIPEDA, as I have mentioned before, that because that is more relevant to our startups. So the Office of the Privacy Commissioner of Canada enforces the data privacy laws in Canada. In Canada, the personal information is owned by the employee and not the business organization. So if you look at it from the perspective of an employer-employee relationship, the employee is the owner of their own personal information, because when you go and take a job into any organization, you may provide them with a number of data like your name, your address, your maybe even your any details like your education, your background, everything they have of you, and your email ID. And any leak could be dangerous for you. It can even your information falling into the wrong hands could even lead to some criminal problems for you. And so it is important for an organization to ensure that your data is protected, not just of its customers but of its employees as well. And the laws in Canada derive from the European data privacy laws, and the main European is the GDPR, and these laws are quite strict in terms of privacy. And so the current federally applicable law is the PIPEDA, and it regulates the collection of personal information, usage of the particular information, any disclosure of personal information in the course of commercial activity, and it is specifically relevant to the private sector. Businesses to which PIPEDA applies must also comply with the DPA, or the Digital Privacy Act, and its mandatory data breach response obligations to maintain the personal information. In November 2020, the federal government proposed replacing PIPEDA with CPPA, or the Consumer Privacy Protection Act, to secure the personal information, though it has not been implemented yet, but it is still in the proposal stage. The benefit of having being data compliant is that uh, like the is that you have to it improves your customer perception. So it is important for the business to so it states that the customer should know that the personal information he or she is sharing with the company could be of some use in line of action, but it should not but should be well noted that it is used only for the purpose mentioned. An example would be that if an email is connected to share a monthly newsletter, it should not be misused to spam with promotional information. Then another thing is that investor readiness. The investor trust can be built through compliance with data privacy laws, and it will be helpful in passing a due diligence test for the same. Uh, PIPEDA was enacted in early 2000 to ensure that the private sectors are protecting the personal information shared with them. Some provinces have passed their own privacy legislations as well, and such as British Columbia. And PIPEDA, but PIPEDA covers particularly those provinces which have yet to pass their own legislation. And so the principles of PIPEDA are these 10 principles are provided under Schedule 1 of the PIPEDA. So it provides accountability, which states that the business organization is accountable and responsible for any information it has collected from its employers. It should appoint a privacy officer to ensure the information is protected. Identifying purposes. Business organizations must know the purpose for which personal data has been collected before or at the time of collection to ensure that the particular data is not misused. Consent. Individuals' consent is needed for the collection, use, or disclosure of personal information. Without prior consent, no information should be stored by the business organization. Limiting collection. Information must be collected through fair and lawful means and must be limited to the data needed for the purpose identified by the organization. Limiting use, disclosure, and retention. Personal and private information should only be used or disclosed for the purposes under which it was collected, as informed to the individual whose information was collected. It must only be kept solely for the duration required to serve those purposes, unless the individual consents otherwise or it is required by law. The individual should also have an option to opt out. Accuracy. Personal information must be as accurate, complete, and as up to date as possible in order to properly satisfy the purposes for which it is to be used. Safeguards. Personal information must be protected through compulsory security safeguards against loss or theft, as well as unauthorized access, disclosure, copying, use, or modification. Openness. A business organization should be open about the set data privacy policies they are abiding by, and this should be informed at every level of the organization. Individual access. An individual must be allowed to use the personal information it has shared with the organization as and when needed. Challenging compliance. An individual can challenge an organization's compliance with PIPEDA's principles and address their challenge to the company's privacy officer in charge of PIPEDA compliance if any breach of personal information takes place from the organization. Requirements of PIPEDA compliances. Consent of an individual should be taken before disclosing any information. Individual must be given access to personal information and a right to correct any inaccurate information recorded. Individuals should be informed the ways in which their information is being safeguarded by the organization. Additionally, in addition to the previous slide, the individual should also have the right to get any particular information deleted from the servers of the collecting organization if they require. Penalty for non-compliance with the PIPEDA. Non-compliance fines could be up to 100,000 CAD for companies that fail to abide by the PIPEDA. Exemptions from PIPEDA. A federal government organization is listed under the Privacy Act. Uh, a territorial government, a provincial government, a political party, a hospital, school, university, or a municipality, which is basically any organization with a social cause. And an organization exempt from PREPIDA if it is collecting personal information for journalistic, artistic. So basically, it is on those organizations which are using information for commercial purposes. Now in the next slide, I will request Arushi to kindly elaborate on the points and carry forward from now.
Sure, sir. What is personal information? Meanwhile, Shashwat sir just said us that the organization should protect personal information in the course of commercial activity. But everybody was be having a question in their mind at what accounts as personal information. A personal information accounts of any data which is sensitive to an individual. It could be an employee, it could be a customer. It should be protected and well informed to the customers, employees, that for what reason it's being stored. Like the organization should well identify its purpose and how it is going to be executed. Failure of which can land the business in extreme trouble. It can land you to legal suits and everything of that sort. Every startup should follow the set data privacy regulation for protecting the personal information. Some of the data which accounts as personal information is shared in the next slide. So, what accounts as personal information? It could be your name, your address, your age, ethnicity, your medical information, your credit card number, your income level, identification numbers which can be used to identify your address or particularly you, your personal opinions, comments, or evaluations, your social status in the society, your disciplinary actions, and the employee files because it stored a lot amount of data stored by an employer, your credit or loan records, a record of dispute, any commercial intention or professional intentions also are recorded as personal information. And now you've collected the data, personal information data from your customers and from your customers and employees. Now, how you should protect that data? Firstly, an organization should classify the data, like what is of utmost importance and what can be shared to the third party. And the data which is of utmost information should not be put on the cloud app because it can easily lead to any breach. An organization must know its threshold capacity of risk bearing. Every organization knows that this amount of data can be put on the cloud app and this can be sorted in any legal dispute. But above than that, should not be allowed to use with any third party or any cloud app. Information of the third party should also be maintained, like which is a third party, where it is located, which information is going to be shared to the third party in the due course of commercial uh, business, and mitigation plan if any breach of data happens. We should diminish liability in case of a breach, and then what remedies should be provided, and how can further leaks of private information be prevented. The organization should only store relevant data. It should not ask its employer customers to ask for any other data other than which is relevant for use. Regular system checkups should be there in practice to detect any loophole in maintaining the data brief's privacy breach. Now, Sir will tell you what to do when a breach of personal information actually occurs.
Thank you, Arushi, for your information. So now we'll elucidate on what to do when breach of personal information occurs. So the first step would be to notify the employers and dealers involved in the commercial activity. And then the next step would be following pre-established privacy brief procedures, which the startup has to comply with. Then then the next step would be that the organization and the complainant should resolve the issue with the help of a privacy officer. And then the next step would be early resolution outcome, in which Office of Privacy Commissioner should be involved for a better outcome. This stage, or the investigation stage, is the one in which the Office of Privacy Commissioner will issue report and find a suitable outcome on how to go about with the investigation. And if any organization chooses not to go about it, it can move ahead to the federal court in order to uh, change the whatever terms the privacy commissioner has put forward. And then the steps would be that they will publish a notice confirming that they have made the changes, change the practices to so that they are not compliant with PIPEDA, pay damages to the person who put forth the complaint, and then those will be the steps. And then so now I will discuss about what are the harms which can occur if you don't protect the personal information of your employees or your maybe your clients, whoever are the stakeholders. And so one of the major this thing is bodily harm, because for example, you maybe have an information regarding a person's address might get leaked, and then as a result a criminal minded person might get access to that person and harm them physically, and it can be catastrophic. Humiliation would include that maybe, for example, we I have a lot of information or a lot of pictures on Google Drive, which might get released publicly, or and it could be a major catastrophe for a lot of people, damage to the reputation of the organization, loss of employment, business and professional opportunities, identity theft, financial loss to the business. It can cause major financial loss to the business when very private information is released, and as a result, they will lose customers. They will also might have to pay a lot of damages, so it will cause major financial loss. And it might also cause negative effects on the credit record. And then the next step would be consequences of not abiding the privacy laws in any startup. I would like Arushi to kindly elucidate more on this topic.
Yes. So the consequences of not abiding the privacy laws can be very catastrophic because firstly you'll failed investment. No investor wants to invest in any startup which is not protecting the personal information of their customers as the employee. So they'll be reluctant to invest in any of that startup. Therefore, you will lose investment. You lose the value of the business if you're not getting much investment, much customers because you're letting out their private information. So ultimately, your business is suffering a lot, and you will lose customers because customers also want their information should be protected because they'll suffer bodily harm and all the information which sir has said already. So they are also very reluctant in buying or availing the services of a startup which is not abiding by the privacy laws. Extra expense on legal suit. If any customer investor issues a legal notice against the startup, has to bear an extra expenses on that also. Further, it would be a reputation damage. 'Cause a startup also suffers reputation damage because if you're not abiding by the privacy laws and with the advanced internet and technology, your a startup would be very demeaned that it is not following the privacy laws. The private information is out in the public, and you should also have to issue fine for breaching the data privacy applications. Now it is mandatory data breach notifications. It was the official final notification for these were put forward by the Government of Canada on April 18, 2018. It came into effect from November 2018 to the organization which abide by the PIPEDA, basically the private sectors. This created a responsibility on the business organization to notify the Privacy Commissioner of Canada if they are aware of any breaches or if any secure personal information is out in the public and how they're safeguarding the personal information. Organization must now keep records of all breach of security safeguard for 2 years at least, whether these breaches were reported to the Privacy Commissioner of Canada or not. In Canada, we have 10 provinces, 3 territories, and a federal government. Sometimes provincial laws can be stricter than federal laws, as in case of the Privacy Act and PIPEDA. For instance, British Columbia and Nova Scotia has the two strictest privacy laws so far. We'll go over the provincial privacy laws in another seminar.
So thank you to Lloyd for having us. Uh,
Well, that was an amazing session, sir. Thank you for joining us today. We are sure that the session helps the viewers in understanding about data privacy mechanics in Canada.
Thank you.
Thank you.